Welcome to the Robertson and Easterling podcast. We're glad you found us. I'm Craig Robertson.
And I'm Matt Easterling. Craig and I are both board-certified family law specialists who run one of the most successful boutique law firms in Mississippi.
We are creative problem solvers who take a holistic approach to the individual needs of our clients.
In this podcast, you will hear from real people who talk about the most difficult season in their lives. You will also hear from our network of professionals who help them in the healing process.
So now, sit back, relax, take a deep breath. Everything is going to be okay. You found us, and what you're about to hear is going to help. Welcome to today's show. Today we have with us Judge William Singletary. Judge Singletary is one of my absolute favorite people. He was on the bench my entire career, and today he's here to talk to us about Chancery court practice and his new mediation practice. Judge Singletary, thanks for spending time with us today.
Thank you, Craig. I appreciate your invitation, and back at you on all those comments about admiring and befriending me.
So what's retirement like? What's it been? You've been a public figure for 34 years, and you've been retired for now less than a year. How's it going?
Well, it's nice not having to get up on Monday morning and put on the customary uniform of a lawyer and go to court. But honestly, I hadn't really stopped working. I work 2 or 3 days a week. I'm doing some mediation work, which has really picked up, and senior status judge, which means I take appointments from the Supreme Court for cases where other judges have recused themselves, and that might take me out of town. I've got several cases in Brookhaven and Decatur and, kind of around the area. So I'm staying busy, yeah. But it's nice, though, not going to work every day.
Is there anything you miss about the bench?
I do. I really miss the staff and the people around the courthouse. I didn't say this. I'm family master now in Hinds County by appointment of the senior chancellor in Hinds County. So every Thursday, 1 day a week, I go down to Chancery Court. My same digs. I just moved down the hall a little bit and hear the Department of Human Services child support and paternity docket, which is a little bit different than what I was doing, but it gives me the opportunity to be back in the courthouse and visit with my friends, and which I enjoy. So
for those people who don't know, as a Chancery court judge, and for our listeners, the Chancery court judges are the judges that hear all the issues concerning families. They hear divorce cases, they hear child custody cases, and they also hear estate cases dealing with land, cases dealing with lunacy, conservatorships, guardianships. What did you spend most of your time doing in the 24 years of being on the Chancery bench? Would it be divorce cases, custody cases? What would it be?
About half of the Chancery docket in Hinds County is domestic family issues, divorces and child custody and stuff. But also, because it's Hinds County and the seat of state government, we hear all the appeals from state agencies. So a lot of the work is that as well. So, it's a variety of stuff, which is one of the good things about the job. There was never a day that was like another day.
So in 24 years on the bench, do you have any idea how many divorces or custody cases you presided over?
Well, it'd have to be in the thousands.
It would be, yeah, it would be. I assume in the thousands, but I don't really know.
Are there any of them that still keep you up at night, or that you remember over time?
One of the things one of the characteristics you have to really have as a Chancery judge in particular, any kind of judge, but I think more important for a Chancery judge than any other is you got to be able to leave it at 5 o'clock. It was rare for me to think about and worry about something I had done, over the weekend or after I went home. It's not to say there weren't some cases that affected me like that, but you just have to put it aside, as you guys do. You can't take your client's business on personally.
I know that Marty speaks the Enneagram language, and I'm sure she's probably pinned you as a particular...
I'm a number 1.
Yeah, perfectionist, absolutely. So I'm an 8. I'm a challenger.
Oh, okay.
And which, great for your lawyer, not so great for your husband.
Right.
And I, and that's kind of, I get wrapped up in the challenge of it. But as a young lawyer, I'm not a young lawyer anymore, but as a young lawyer,
You are a young lawyer,
Well,
as is Matt. Claim it while it's yours.
I don't feel that way.
So yeah, it's some of the cases, it's just hard to leave them at the office. I tell people all the time in my initial consultations that, there are certain people in the world that are very difficult to surprise, and divorce lawyers and chancellors are among that group. Now, every now and then, somebody they'll surprise me, and I'll tell them when they do. I was like, well, you know what? You got me today. I've never heard that particular one today. And I'm sure you had that experience while you were on the bench too.
Oh, yeah. Certain set of circumstances could sneak up on you sometimes. But then again, there was always, actually one of the dangers of the job is particularly in a domestic family issue or divorce case, you had to be very careful not to just categorize this immediately. You start hearing a case and you hear so many that are similar that you start hearing common characteristics, and you think, oh, that's box number 56. You've got to be careful not to make assumptions about where this case is headed and not zone out on them.
What trends did you see? Because you were, my whole career, you were on the bench. Is there some trends that you recognize as the dynamics of families in Hinds County particularly, or in Mississippi generally, that you saw changing over the tenure of your six terms on the Chancery bench?
Yes. I think fathers, by the end of my career, fathers were a lot more engaging with their children and more anxious to be awarded custody and to have more than what we call the standard visitation, every other weekend. They would be expecting or requesting more the week on, week off, or more time, that, getting closer to the 50% mark. So I'd say that over time was a change I saw.
We're going to have a whole episode devoted to that, kind of the role of the modern father. Yeah. And I'm really glad that you brought that up, because, more and more, even today, I had a consultation with a dad who wanted to rearrange his original custody agreement because of that very reason. Why do you think that is, Judge? Is it the more women actively in the workforce here, or what would you attribute that to?
Well, I don't really know what exactly it would be the cause of that, other than just in the overall broad sort of rubric of education. I just think as a society we have just educated folks to the advantages of children and having both parents available for their care and love and nurture. And so, I don't know exactly why that is, but it's a good thing. I like to think of myself as an optimist, so I tend to think that these social trends are mostly good, or at least more good than bad. So, I see us headed in the right direction.
Well, so, Your Honor, one thing I think that is got to be very interesting is, considering when you took the bench, there have been a lot of societal changes that we have seen from when you took the bench to when you retired, namely cell phones and social media.
Sure.
How did those two societal influences change what you saw in the courtroom?
Well, the most obvious change is lawyers would come in with their case prepared to offer evidence against the opposing side that they had gathered through social media. And not just social media, but texting and sending pictures and incriminating evidence over digital means, in all forms. But yeah, so social media obviously has been a real boon to gathering evidence for you guys, I know.
Well, and in my opinion and in my experience, there's really absolutely nothing that a party to divorce litigation can gain from social media by putting things out there on social media. Would you agree?
Oh, absolutely. Now, you're talking to somebody, I probably ought to refer to myself even as a dinosaur in this regard, because I don't do Facebook, I don't do Snapchat or whatever all those things are. I just, it doesn't really interest me. I don't really care to know that much about, what's going on with that many people. Maybe a handful of people, but anyway. So I don't see it as anything that is beneficial, certainly. And if I was one of you guys counseling potential divorce litigants, I think the first thing I would tell them is you have got to drop yourself off of all of this stuff during the period that I'm representing you, and extract a commitment from them on that, really, because there's nothing good to be gained for their case.
I started practicing in 1999. And you had already been on the bench 5 years. You've actually been on the bench up until the last few months, my entire career. And I can remember early on some of the cases back when everybody had a house phone. And, it was one of those cordless phones. And I can remember the very first juicy adultery case I was ever involved in. And this girl had met her lover on like America Online or something like that, which was this hot new thing. And so her husband was suspicious because she'd take her cordless telephone and would go out, and they had a swimming pool. And so she'd go out in the backyard and kind of walk around the swimming pool. Well, this guy was what I thought like a genius, tech savvy. So he got a police scanner and he put it in the pool house. And I can remember people in my neighborhood doing this. They'd get their police scanners and they would like set it to some certain frequency and like listen to their neighbors' conversations and stuff like that. Well, I lived in South Jackson. So this guy, he did that. He set set it next to a voice activated recorder, set it in the pool house, and captured just hours of her on the phone with her lover. And, it's funny because I'm 45 and here we are in technology with GPS tracking and Snapchat and social media. There's 30 different apps that a person could use to privately communicate with someone. It really is I don't want to say the Wild West, but I mean, there's just so much technology out there. And without even getting into all the academic stuff about how evidence works and authenticating different types of communication. I'm a parent. I've got two daughters. I've got a 15-year-old and a 14-year-old, and Matt's got a young daughter. And we've had these communications about, I'm the first generation of parent who has to circumnavigate Snapchat. And, it changes. And so, judges are the same way. So there's these waves of technological changes and trends that change what you experience.
Absolutely.
Well, so I've been practicing a little over 10 years. So the majority of my practice has, taken place during the cell phone and social media wave. But not only are all those things, are there so many different outlets that are, at our fingertips, our culture has changed to where everybody feels like they need to say exactly what they think and they need to basically publish it. And I know, Judge Singletary, one of the first big cases that I ever did in my career was in front of you, and it dealt with a man that felt compelled to just write the most vile things into emails and send them to his wife. And I mean, the entire thing, I was just harvesting hundreds of them at a time, and I would make him read them in court. But I would think sometimes, like, I don't know what a lawyer would have done 10 or 15 years ago, because this is how this man has treated this woman and their children for the last decade. But until email and text messages, how would you have been able to actually convey exactly what it was that he was doing at home? Because I don't know that you could just get up there and say, well, he called me this.
You guys' jobs are made a lot easier in some respects nowadays than it used to be.
Except for your client sticks their foot in their own mouth.
Well, sure.
Which makes it harder.
I hope you're enjoying our show. My name is Cassie. My job is to take care of the Robertson and Easterling clients. I love helping people. Listen, the lawyers in our office are some of the smartest people I know. I know that you're scared and emotional, and that's totally okay. But when the plane's going down, it's important to put your oxygen mask on first before you can care for those around you. Request a consultation from our website or just give me a call. Everything's going to be okay. I can't wait to meet you, but until then, sit back, relax, and enjoy the second half of today's show.
I wanted to ask you about one thing. And what did you do, Judge? I mean, you heard probably thousands of cases, with a pure he said, she said case. I mean, I know every case is different, but I mean, you've got the wife saying one thing and the husband saying something the exact opposite. I mean, what do you do with that?
Well, that's where it just comes down to credibility. And it was my job. It is a Chancery judge's job without a jury there, because it's my responsibility in Chancery court. No juries. It's your job to judge the credibility of the witness. And when it was he said, she said situation, you just had to watch them very carefully through the entire trial and be prepared to kind of go either way once you saw which one of them finally convinced you by something they said or some inconsistency or obvious and material inconsistency. And a lot of times you were withholding judgment on that point until they had enough rope to hang themselves, whichever was the less credible one of the two. It was hard. It was much harder. Yeah, I always liked it better after we got more readily available incriminating evidence from that we've been talking about. So it made my job easier.
How hard is it? I mean, I tell people I've got this. It's actually a crystal ball. It doesn't work, but it's a crystal ball. And I said, look, if I could read people's minds, then I probably would be doing something other than being a divorce lawyer. But you're sitting there on the bench, you're listening to these cases, even with two good lawyers are presenting their case. I mean, every case is different, of course, but sometimes is the right thing obvious? Is the equitable thing obvious? Or is it something that you just have to labor over?
Oh, no. Many cases are obvious, or what you think is likely to prove to be obvious by the end is known to you early in a case. You know how lawyers are. Sometimes they will over-prepare and go on forever when it would be better just to set out a simple defense of their client or prosecution of their client's position and let it stand at that. However, I have had that conversation before with lawyers and learned that if a lawyer can't read you as the judge, then they got to be prepared to just keep going. Well, I don't know when he's heard enough, that kind of situation. I don't think I had a poker face on the bench. A lot of lawyers would tell me they could tell what I was thinking, but apparently I didn't signal it as much as I thought.
I always thought you were very patient on the bench. I know what happens when lawyers go back in chambers, and I tell people what happens when lawyers go back in chambers, and I believe that most of the time they believe me. But is that useful for you when lawyers? I think clients get afraid. They're like, oh, there's this. They're back there cutting deals, and I'm being left out of the conversation. What did you find? I know that you like to have lawyers come back and talk a little bit informally about cases. Is that a good thing for litigants or a bad thing?
The criticism of me, I think that was most justified, probably, other than preferring to start at 10 o'clock instead of 9, was that I did too much of that. I didn't keep in mind what the clients were thinking when the lawyers would come in chambers with me to discuss the case before we started. Now, I do think it is more efficient, but I should have been more cognizant of what your clients were thinking. Occasionally, a lawyer would tell me, Your Honor, we just need to make sure that I want to make sure my client hears some of this, so or we don't spend too much time doing this before we get started. But that was kind of rare. Lawyers are not. They're reluctant to be that direct with the judge, so I wouldn't do quite as much of that as I did.
Well, I think that I find a lot of clients sort of expect a very dramatic seen in a courtroom, whether it be a trial or hearing, and also almost a dramatic conclusion to it. Whereas, I tell people it's usually best to just kind of look for what the practical solution is, because it's not going to come across like it does on TV. There's not going to be some big smoking gun moment. It's okay, what is the most common sense, practical way that these pieces can fit? If I understand you don't want to pay for XYZ, but there's no way that your spouse can. So that's going to have to go in your column, things of that nature. And I think it was made worse sometimes when we would go into chambers and they didn't understand how that conclusion was come to.
I want to show you a picture, Judge. This is the last official time that I was before you, appearance, was the adoption for this little family. This is the Hillman family, and that's Su Ling, a girl who was adopted from China, and her little brother, Jesse. And I don't know if you remember this, but
I remember it well.
Yeah, I was there. It was November of 2018, and you got a little emotional about this adoption, and I get a little emotional looking at the picture. Talk a little bit about, when you get to see the good in people, because I know that as a Chancery judge, you hear about the adultery and otherwise good people doing stupid things, but how does adoption change that for you?
Yeah, well, adoptions obviously were the most, I don't want to say fun, but the most rewarding thing, thank you, that I ever did. And this one in particular, I know the young child from China that was being adopted had some medical condition. I don't know exactly what medical condition that was, but it's a very visibly, physically obvious thing. And this little girl is, I'm guessing, 6 or 7?
She's really young, yeah.
Yeah. And she, just for this family who had 2 other children who were in this picture with them, obviously just had it in their heart to save this little girl and to love her and make her part of their family. And that's something that's wonderful.
Your Honor, I know you mentioned that you're not completely retired. You've been doing some mediation since you stepped down from the bench. Tell us how that's been going.
It's very rewarding to take 2 clients who are about to litigate their divorce and, in the course of one day, bring them to a compromise that they can both live with. It's reduced to writing, signed off on, and they walk out of there, if not loving the outcome, at least relieved that they didn't go to court and didn't spend any more money than they had to on you guys, or more pointedly, didn't have to do battle in court and hack away at each other. So, it's a very rewarding thing, and it's kind of the way I would try to approach the job when I was on the bench. So it was one of the things we were doing when I would call you guys in chambers, and I'd say, okay, where do we need to how can we figure out some sort of compromise that would work here instead of spending all day eliciting testimony that might not be forgotten for a long time. So it's been a real rewarding experience.
I've heard different mediators who were former judges talk about that they know way more about a case after a day of mediation than they did
absolutely
when they were on the bench listening to testimony. You agree with that?
Absolutely, because you're not confined to taking what you learn about it in little bits that are admissible in evidence. If you just go in a room with somebody and say, what's the situation here and what's your beef, they're going to tell you everything, and there's nobody there to say objection, Your Honor. So you learn a lot of stuff in there in a concentrated period of time.
Right, and sometimes people talk about needing their day in court, and I talk about with my clients about how every dispute has kind of an emotional component to it, and then actually the hard and fast facts which resolve an issue. And, if you skip the emotional component of a dispute and try to skip right over to the hard and fast resolution, sometimes you find yourself going in orbit. And if you stay there in the emotional stuff, you just sit and spin. It's like you're stuck in the mud. But when you move through the emotional piece and you land on a resolution, and that's something that mediation offers, it gives an opportunity to tell one story, to tell their story to an authority figure. Would you agree?
Right. I don't know to what extent a litigant would feel telling a retired judge their story, whether that aspect of their need would be satisfied rather than telling it to a judge in a black robe on the bench. But I think there is that opportunity to have that need met, and mediation is a wonderful way to go. I would say if there was any criticism that I would have of lawyers coming into court to try a case, it would be that some lawyers had not prepared their clients with reasonable expectations for the outcome. And in a mediation, that's what the first thing to do is to have everybody understand that this is a compromise. You're not going to, if you've got a hard and fast position on something that you're not going to back off from, or on most things that you're not going to back off from, this isn't going to work. So reasonable expectations have to be a component of not just the courtroom work, but mediation too.
Yeah, and I think a lot of people don't understand. I like the analogy of an iceberg. It wasn't the part that was sticking up that sunk the Titanic. Right. It was all the big chunks of ice underneath the water.
There.
And a
I'm
chancellor.
I'm going to use that.
Oh, you're welcome.
Yeah, okay.
A chancellor. They're limited because of the rules of evidence to that piece of ice that is sticking up out of the water. The lawyers and the litigants and their family, they have the benefit of the rest of the iceberg under the water. And a mediator gets to peek into that outside of the confines of the rule of evidence, if you will.
Exactly. So, Singletary dispute resolution services is the way to go.
Well, and look, I agree. I would mediate every case, but sometimes people aren't ready. And sometimes people aren't emotionally ready. Sometimes the information exchange hasn't happened, but I'm totally in favor of. I don't know that I've got two thoughts about it. Mandatory mediation. If somebody doesn't have skin in the game, if they're not willing to step into the process, sometimes it's less beneficial than if they're forced to be in the process. But most smart lawyers, I think the higher end, there's a lot of smart lawyers in Mississippi, but the lawyers who do this day in and day out, most of them understand the value of mediation, because at the end of the day, we're trying to provide good service to people. I mean, we don't represent Walmart. We don't represent big companies. We represent everyday people. And, a $10,000 legal bill, or goodness, a child custody case, a $80,000 or $100,000 legal fee bill, that's a game changer. I mean, that's a Harvard education for, well, maybe not Harvard anymore, but certainly it'll get you an education at Ole Miss.
It's 1 year of Harvard.
Right. Yeah. Judge, I just wanted to ask, how important is it for someone who is facing family conflict to have an attorney?
It's essential. It's vitally important. And I'm not saying that just because you guys are sitting here in front of me and invited me into the conversation, but a layperson cannot be expected to know sufficiently know what their rights are to resolve a case without some kind of legal advice. Now, whether it's dropping a $10,000 retainer on you or just going and talking to a lawyer ahead of time, there's more than one way to do that. But you've got to go into that process with legal advice, benefit of legal advice. Yeah.
Judge Singletary, thank you for taking the time to be here with us today to do this. I really think that, our goal is to arm people with information, and I think you've helped us do that, just a view from the bench, and thanks for spending time with us.
Oh, it was my pleasure. Now I can add podcast to my resume, see?
Yeah, man. Me too.
Thank you, guys.
You've been listening to the Robertson and Easterling podcast. Thanks for spending time with us.
We'd love to hear from you if you need our help. You can request a consultation from our website in less than 5 minutes. If you liked our show, please subscribe to our podcast so you'll be one of the first to know when our next episode drops.
Have a great rest of your day, and remember, there's nothing wrong with arming yourself with information. On behalf of Matt and our entire team, thanks for listening.
This podcast is not a substitute for an attorney. All information is provided as a general reference and public service. Listening to this podcast does not create a professional relationship with Robertson and Easterling or any of its attorneys or guests. This podcast may be considered advertising under applicable rules, and free background information is available upon request. For a full disclaimer, please visit our website, www.robertson.ms.